What's up, guys? It's the Wolf, and as always, we just keep getting better on this channel, don't we? Fire information. You know you're doing something right when the trolls start coming out and trying to bother you on, on their channels about your channel, because they can't bother you here. Sorry, guys. And that being said, if you guys see anybody using any of my materials, likeness, or logos or whatever else without my permission, and especially in a negative way, calling us out of our names by the S word or whatever else, feel free to use the report button over there on your app and report them for bullying, harassment, dangerous speech, whatever else, whatever you got to do. Don't lie, but if it's true, then use it. So, that being said, let's go. So this particular video is about criminal law. Now, once again, this particular sheet is from Bar Charts Incorporated, okay? Or else you can look up quick study sheets, and that will help you find one of those two companies. They're parent and sub company, but they have tons of these sheets, guys, with all of these gems. I mean, look at this. So these are all cases so you can learn not only what's going on, but how to use their own materials against them. Now, some of these are cases, and so the lower courts, which are not Article 3 courts, may utilize some of this, but if they don't, you will have to take them to federal or Supreme Court in order to attack them in a situation where the case law comes into being, in which case you will be the plaintiff, and the plaintiff usually wins, and they will be the defendant. Okay? So, let's take a look. The first one here, act. Okay, so an act means the definition is a voluntary act. Actus reus is satisfied by either a volitional act or an omission. Okay, voluntariness of acts. So basically, this is telling you that you have the right to provide information, the right to not provide information, and to also not incriminate yourself. The next section is specific intent. Involuntary intoxication is accepted as a valid defense to mens rea. Okay? So they're basically saying that you can use the defense that you were involuntarily intoxicated. Mistake of fact. Even if the mistake is unreasonable, if it's done in good faith, is a defense to mens rea, okay, to the truth or to the act. So, if you did something and you didn't know from the best of your ability that this was a wrong thing to do, you can use it as a defense. Voluntary intoxication, okay. It says, common law jurisdictions draw a distinction between specific and general intent crimes. Modeled Penal Code MPC jurisdictions do not. Requirements, okay, it goes on. Conspiracy, assault, forgery, false pretenses. Okay, so general intent. So in order for this to be a crime, it says all crimes require general intent. So if you didn't have the intent to do that, or for that, that is a defense you can use. General, so somebody got an OW, you could say, well, first of all, I had no intent on getting drunk. I was involuntarily intoxicated, and you've got a defense. Remember, this is all educational, entertainment information only. I'm not a lawyer. But as you guys can see, this is where I learned my stuff at in other places. So if you don't know the rules, how do you expect to win? Mistake of fact must be honest and reasonable, but cannot be legal or morally wrong. Okay. Transferred intent. Somebody led you up to that scenario. So the next one we got where it talks about strict liability. You had no intent. Crime does not require awareness of all factors. Okay, so they're going to tell you what you can and can't get away with. So here, classification of crimes: felonies, misdemeanors, mergers, double jeopardy, sexual assaults, homicide. Okay, next you got defenses and justifications. Duty to retreat rule. Okay, let's see what this says. At common law, one must retreat rather than use deadly force unless at one's home or business. Okay, so in common law, you must retreat rather than use deadly force unless you're in your house. So in the higher courts, this would stand. On the lower ones, they'd be like, no, no, no. Deadly force may only be used in self-defense when it is reasonably appears necessary to prevent immediate death or serious injury. Non-deadly force, okay, so all that stuff is going on. Imperfect self-defense. Okay, let's see what that says. Some jurisdictions allow for a partial self-defense theory which would not justify one's actions, but instead mitigate the punishment to a lesser offense. Okay. Defense of others, defense of property, duress, excusable, not justifiable. 1. Defendant contends that because of human threat, he or she is the victim. Okay. Tells you which cases and how you can or can't get away with some of these things. Other defenses, entrapment. The criminal design must have originated with law enforcement, and the defendant was not predisposed to commit the crime. Entrapment. Gotcha. Okay, consent. Diminished capacity. Some states recognize as a defense where, as a result, the mental defect defendant did not have the state of mind required for a specific crime. Differs from insanity. Involuntary intoxication kind of jumps back and forth. Taking an intoxicant substance without knowledge of its nature, or under duress, meaning you were stressed out, or under medical advice. Okay, so this right here has been more effective than a lot of people's lawyers out there. I could probably get off 5 people I know right now just with this. Constitutional defenses, okay? They went overboard, void for vagueness, cruel and unusual, death penalty, purpose of the punishment, proof of burden. So let's get into this one. So proof of burden. All material elements of a charged crime must be proven beyond a reasonable doubt by the government. Federal jurisdiction, federal territory, D.C., federal grounds, federal courthouses, national parks, naval yards, jurisdiction over conduct of U.S. citizens abroad, maritime jurisdiction, all persons on U.S. ships, aircrafts, including those in foreign waters and ports. Kind of like going into a courthouse. Accomplice liability, casual relationship between conduct, offenses, defenses, ignorance or mistake of fact or law. I'm telling you guys got to get one of these, or all of these. Let's see. Hang in here. All right, let's see. What else we got? All right. So I got 2. Yeah, got 2 more to go. All right. So that's it, guys. Check out the next video, and I'm going to be breaking down civil procedure, how they move, basically, and the justice, criminal justice. So check out the next vids. I'll talk to you guys later. Don't forget to hit that bell, like, subscribe. Later.